So liability and cost traps is kind of three key areas to talk about here. Number one, laws, rules, and regulations. If you are dealing with GDPR at all, if you're dealing with international customers, you're probably familiar with the concept of data processor, data controller, some of these ideas, right? So if you're used to GDPR or having to deal with a customer that's subject to GDPR, you're already kind of thinking about some of these terms, right? In the US, we have a much different framework for privacy. We've got kind of regulatory oversight in the form of the FTC. We have some other oversight in the financial industry. We've got some oversight in the healthcare industry. And more recently, we have, I think it's now up to 6, maybe 7, at least 6 state privacy laws: California, Colorado, Utah, Virginia, Connecticut. I can't remember the 6th one, but of all of those, okay, Utah, Colorado, Connecticut, and Virginia specifically adopt the same terminology as GDPR and require things like privacy impact assessments. So, you know, from just a state compliance standpoint, number one, this is totally new. You know, number two, you know, it needs to be in your contracts, because these state laws require that your contracts address data sovereignty and data privacy and data security. Not all of the laws have come online, although most of them have. And it's sort of evidence of the trend here in the United States, right? Is all like potentially 50 state laws governing data privacy. I don't think that's going to happen. I mean, it's my own personal opinion. I suspect there will be some sort of a national privacy law before we get 50 different state laws. But from a contracting standpoint, right, if you are in one of these jurisdictions, or you have a customer in this jurisdiction, or you have a vendor in this jurisdiction, you need to be thinking about what governing law does the contract have? How does that state's data privacy laws impact what we are doing in our relationship? You know, are we dealing with personally identifiable information? Is this, you know, healthcare information? Is this data that requires a heightened level of security, right? So those kinds of things are impacting contracts. I mentioned earlier sort of the battle of the forms, right? This is just, you know, it's a time sink when you're going back and forth and trying to figure out which form to use and you know, how to get the process completed. The third area, third parties, is a whole host of other types of issues. When we talk about third parties, you're talking about HR people who are potentially dealing with data from, you know, employees, prospective employees, departing employees. You have third-party vendors. You know, and depending on the enterprise, you could have vendors for all sorts of things. You could have vendors for marketing. You could have vendors for HR. You could have vendors for, you know, the back office systems, all of whom need to touch your data, potentially customer data, right? And in the scenario where, let's say you've hired an outside marketing firm to, you know, do some sort of project for your existing customers, right? So here you have an outside third party who you have to give access to, you know, your customer data, right? So, you know, that is a very large risk in terms of, you know, being able to understand what they could possibly do with that, what liability is there for you in terms of sharing that, what liability is there for you if they misuse that data, okay? So all of those things become part of the conversation. Again, thinking back to this idea of a data privacy addendum or something like that, if you have, you know, vendors and there's major gaps in their data privacy or data security, you can just add an addendum to something like that to kind of build up that part of the relationship without having to rewrite the whole contract.